Last year, I believe that the Office of the Prosecutor has been very gainfully employed, and I believe has given good value for each dollar in the budget. But I think there are two events of primary importance since the last dialogues that I would like to discuss. And the first of those events occurred in September of last year, when the Special Court Appeals Chamber delivered its unanimous judgment in the appeal of the Charles Taylor case. And in that unanimous judgment, the Appeals Chamber affirmed all convictions in the 50-year sentence of Charles Taylor. Now, in addition to its historic value, there were really two aspects of that judgment that I would like to bring to your attention today. And the first aspect deals with the proof requirements of aiding and abetting. And Serge has talked to you about the Perisic case, and last year when I was here, I noted our concern about that majority decision, which we believed was inconsistent with customary international law, the jurisprudence of the two ad hoc tribunals, and also was a very confused majority decision. Our appeals chamber found that specific direction is not an element of aiding and abetting under customary international law, and reaffirmed that what the prosecution must prove is that the accused acts substantially contributed to the commission of the crime, and that the mental state that is required is the mental state of knowledge or an awareness of the substantial likelihood that the accused acts would assist the commission of crimes. We believe that's a very important decision for the jurisprudence of aiding and abetting. We believe that the specific direction in jurisprudence is one that would, in essence, allow top-level perpetrators to basically have impunity for their actions. So we were very happy to have received that decision from the appeals chamber. The second aspect of that case that I believe is worthy of note was of particular significance to me because it's a position I've been arguing since I began at the Yugoslav Tribunal in 1994. And that is, the appeals chamber found that there is no hierarchy among the forms of liability set out in Article 6.1 of our statute. That is to say, there is no hierarchy among the forms of liability of planning, ordering, instigating, committing, or aiding and abetting. But that rather, when determining a sentence, it is individualized sentencing. And so the court must look at the gravity of the crimes, the extent and consequence of the totality of the accused criminal misconduct, and, of course, the personal circumstances of the accused. And I believe this also is a very important jurisprudential decision by this appeals chamber. In addition to the appeals chamber decision in the Taylor case, the other significant event that occurred at the Special Court for Sierra Leone was that in December of last year, the Special Court became the first international criminal court since Nuremberg to close its doors. The Special Court was replaced by the residual Special Court, which has the responsibility of carrying out the continuing functions of the Special Court. And those include dealing with enforcement of sentence, dealing with issues raised by prisoners, dealing, very importantly in my mind, to ensure the continuing protection and support of witnesses and victims, maintenance of the court archives, and in particular for the prosecutor of the residual Special Court to be able to respond to state requests for information. When the Special Court closed its doors, we had one outstanding indictment, and that was against the chairman of the junta that had overthrown the elected government of Sierra Leone in 1997. We have conflicting information about this man, Johnny Paul Karoma. We have information that he is dead, indeed killed on the order of Charles Taylor. But we also have continuing reports that, like Elvis Presley, he has been seen in various places around the world. So he may be alive. If indeed he is alive, if he's located and turned over to the residual court, then if we are unable to refer his case to a state for prosecution, then the residual court would have the ability and the mandate to try this one outstanding indictment. The residual court is a very lean mechanism. We share an administrative platform with the Yugoslav Tribunal, and we owe great thanks to the Yugoslav Tribunal and to Serge's office for their continuing support, which was substantial throughout the life of our court. We have a permanent seat in Freetown, in Sierra Leone, but we have an interim seat in The Hague, the Netherlands, and that is in fact where we carry out our duties and where our archives are placed. Since the residual court has stood up, my primary job has been to put our prosecutorial functions in place to recruit the one full-time position that I have, and that is the prosecution legal advisor and evidence officer. And we have also been very engaged in completing our archiving so that we can do comprehensive searches as needed, responding to 5 state requests for information, 3 of them very complex requests, filing 2 submissions giving our perspectives on and our opposition to the 2 prisoners' requests for early release. We were unsuccessful in both of those situations. They will be released early with conditions. And we also asked the president of the court if we would be allowed to make submissions on Mr. Taylor's motion to the court that he be allowed to serve his sentence in Rwanda instead of in the United Kingdom, where he is currently serving his sentence.